Good morning. This is your Kelso Report for Friday, May 11th, and I'm your host, Clark Kelso. Today's menu includes cases involving HIPAA, parole revocation, death penalty, professional licensing, and unclean hands. We begin with the Ninth Circuit, a case involving criminal law. In United States v. Zhao, the Ninth Circuit faced one of those common questions of statutory interpretation in the criminal law context. Do you have to know that what you are doing is illegal? In this case, the question arose in the context of a privacy violation under HIPAA, the Health Insurance Portability and Accountability Act. The defendant, a former research assistant at the University of California, Los Angeles Health System, accessed patient records without authorization after his employment was terminated. He was charged with a misdemeanor violation of Title 42 U.S.C. Section 1320D-6 as, quote, a person who knowingly and in violation of this part obtains individually identifiable health information relating to an individual, close quote. The defendant moved to dismiss the information because it did not allege that he knew that the statute prohibited him from obtaining the health information. The district court denied the motion to dismiss, and the defendant entered a conditional guilty plea and appealed. The Ninth Circuit agreed with the district court, concluding that the plain text of the statute is not limited to defendants who knew that their actions were illegal. Rather, the misdemeanor applies to defendants who knowingly obtained individually identifiable health information and obtained that information in violation of HIPAA. Next, we have a case involving parole revocation in the United States versus Valley, or Valley. The Ninth Circuit addressed itself to the question, what's in a signature? In the context of a court order revoking a parolee's supervised release. Under Title 18 U.S.C. Section 3583I, a court's jurisdiction to revoke a term of supervised release and impose incarceration or additional supervised release can be extended beyond the date that the supervised release term was set to expire if a valid warrant or summons is issued prior to the date of expiration. The defendant argued that because the summons issued by the court was not signed by a judge, it was not sufficient to extend the court's jurisdiction beyond the April 10, 2010 supervised release expiration date. The Ninth Circuit, avoiding the technicalities, held that a summons based on a petition to revoke supervised release is valid to extend jurisdiction when it is signed and issued by a clerk at the direction of a judge. At least in this context, a clerk's signature doth smell as sweet as a judge's signature. Next, we have a habeas corpus decision from the Ninth Circuit involving the death penalty. In Thomas v. Chappelle, the habeas petitioner had been convicted of a double murder back in 1985 and sentenced to death. The California Supreme Court concluded in its 1992 habeas review that the petitioner had received constitutionally ineffective assistance of counsel at his trial because counsel failed to conduct an appropriate investigation for available witnesses who could corroborate parts of testimony from a witness who testified for the grand jury that clearly implicated someone else as the murderer. Notwithstanding this failure to investigate, the California Supreme Court concluded that the failure was not prejudicial because, based on the evidence that was presented to the jury, it was probable the jury would have convicted anyway. Well, the Federal District Court and a majority of the Ninth Circuit panel held that adequate prejudice had been established by the petitioner. There were three keys to the majority's conclusion. First, the case arose prior to the Anti-Terrorism and Effective Death Penalty Act. So, the habeas standards under that act do not apply. The standards that apply are prior to enactment of the act. Second, the majority agreed that the entirely circumstantial case against the petitioner was not very strong, particularly since the murder weapon was never found, nor was a motive identified. And third, the absent potential witnesses would have supported the grand jury testimony from a witness that was accused by the prosecution of totally making up her story. Admittedly, the grand jury testimony was rather odd. The whole case factually is odd. But these potential witnesses would have confirmed significant parts of her story. Now, there's no big legal issue here, and since the case involves the standards of review prior to adoption of the Anti-Terrorism Act, my guess is that the Supreme Court is going to leave this one alone. It's a pretty close case. I don't see this as one for the Supreme Court to get involved and try to make a statement. Next, we turn to the California Court of Appeal, a case involving professional licensing. The psychologist was appointed to serve as a special master in a family law matter and testified telephonically under oath in a family law proceeding in Florida. The Board of Psychology disciplined the psychologist based on his misbehavior as a special master, which created serious conflicts among the parties, and based on dishonesty in the Florida proceeding. He challenged the board's authority to discipline him, asserting that he was not acting in the capacity of a psychologist in either proceeding. He was a special master. The Third District disagreed. A special master in family law acts in the role of a parenting coordinator, which the literature describes as a hybrid of psychotherapy, mediation, and child custody evaluation. As the Third District explained, the activities of a special master are a mixture of psychotherapy, mediation, and forensic psychology. So, like the Third District said, the board plainly had jurisdiction. The court easily rejected his due process claim that he did not have notice of the rules that guided the board, and that there was not substantial evidence of dishonesty in the Florida proceeding. The Third District upheld the discipline. Finally, a case involving unclean hands. The Third District in Flowers versus Dancy faced a deceptively simple question. Who owns the property and house left by two brothers-in-law who died intestate? Unfortunately, nothing about the case was simple. A complex web of intrigues and deceits surrounded the property, its use, and ultimate disposition. But the case was resolved by basic principles of equity that have stood the test of time. First, everyone agreed with the principle that a forged deed is a nullity, even as to bona fide purchasers, but that a party's conduct may stop that party from asserting the deed as forged. Second, and related to estoppel, everyone agreed that under the unclean hands doctrine, one who comes into equity must come with clean hands. Unconscientious conduct in the transaction may give rise to the defense. In particular, the unclean hands doctrine may prevent a party from attacking a forged deed. I'm not going to be able to relate the entire story here, but suffice it to say that the son of one of the now deceased owners tried to use the confusion created by what everyone agreed was a forged deed. No one knew who forged it, but everybody agreed it was forged. He used the confusion to delay the proper disposition of the home while he took steps to advance his own personal position, leading finally to his attempt to clear title solely in his favor among all of the possible heirs. With the court's finding of unclean hands, his attempt fails, and it appears the bona fide purchaser gets to retain the property, notwithstanding the fact that she secured title indirectly from a forged deed. And that's it for today's Kelso Report. Have a great day in the law.